Good day, folks. You are not going to believe this. We just won in the state of Illinois. There is a rule: if Lori Lightfoot is not happy, you should be happy. And she is now upset. I cannot believe this. Illinois, of all places, we just notched a win. Hey, welcome to another edition of Lumberjack Logic. I'm your host, Neil Johnson. Always excited to be with you and share the news with you. But this report is special. Okay, so one of the things that you find when they write bills is that they always market them by their names. You remember what we called Obamacare, they called the Affordable Care Act when all our insurance premiums went up? Yeah, like that. So this act was called SAFE-T, S-A-F-E-T, the Safety Act, which did nothing to create safety because it allowed criminals to walk free without bail. And what's really amazing about this bill is how similar it is to the omnibus bill that just got ramrodded through the United States Senate by none other than Mitch McConnell. Now check this out. It was this from the state's attorney. The act was a 765-page bill passed during a lame duck session under the cover of darkness at 4 a.m., affording legislators less than 1 hour to read it and vote on it. Does that sound like the omnibus bill? That was over 4,000 pages, but you get the idea. No one's going to read a 765-page bill in 1 hour. This is the kind of shenanigans that these politicians are up to as they try to strip us of our rights to have our voices heard. And that's what this case was about. A Kankakee, Illinois county judge has ruled that parts of the Safety, Accountability, Fairness, and Equity Today, that's what SAFETY stands for, Safety Act, violate the Illinois Constitution. Passed in January 2021 and would have abolished cash bail in most cases beginning January 1st, 2023. So this is just a little bit before it was set to take place. You can remember what happened with the low bail set in Waukesha County when we had the Christmas Day parade incident, okay, which they called an accident, but wasn't. So what happened here was the Democrats wanted to ramrod this through and take all power away from the courts and power away from the people because they have to actually amend their constitution to do this. Of course, we know Democrats don't care about constitutions, but understood. Echoing the state's attorney's arguments, the judge wrote, "Bail exists, as it has for centuries, to balance a defendant's rights with the requirements of the criminal justice system, assuring the defendant's present in a trial and the protection of the public," because you can't have people just running out on trial and going out and doing their dastardly things like we saw with Waukesha and numerous other places, okay? The state constitution, Cunnington wrote, that's the judge, explicitly provides that the safety of the victim and the victim's family must be considered in denying or fixing the amount of bail, determining whether to release the defendant, and setting conditions of release after arrest and upon conviction, Cunnington wrote. So there you have it, folks, a big win in Illinois. I will link to the article below if you want more. And remember, subscribe to the channel if you're new and support my sponsor, MyPillow, MyPillow.com. Promo code Lumberjack will save you big money on the best sleep products available. Peace out.